Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode 36, we're going to continue yesterday's discussion on trust reformations, fixing drafting and scrivener's errors. We're going to look at how those can affect tax law, which is federally determined in a lot of cases. Now, as always, this presentation is not intended to substitute for legal or tax advice. So, yesterday we discussed scrivener's errors, which are drafting mistakes in a will or trust that tend to violate the intent of the person creating the will or the trust. And what we looked at is the fact that a court can reform a trust or a will by adding words or subtracting words if you can show clear and convincing evidence that the mistake did violate the intent of the person creating the will or the trust. Now, yesterday's discussion was driven primarily by the fact that a mistake like this could affect the distribution rights of the various heirs and beneficiaries under a will or trust. However, a drafting mistake could also affect the tax law treatment of a trust or the beneficiaries or even the settlor of a trust. So, what effect does a reformation have on tax law? Well, that's really what we're going to look at today. And this is a discussion that's more academic in nature, but should have some nuggets throughout that can help you in the process. Now, it's important to note once again that trusts and property rights are generally controlled by state law, but many taxes are primarily driven by federal law. So, when it comes to the conflict inherent between the two, the IRS will generally give deference to state law property rights because that's not in their wheelhouse. It's not up to them to substitute for a state court or state law to determine property rights. And we previously discussed that a bit in episode 6 and looked at the fact that good drafting in some cases could save you and allow for changes to satisfy changes in tax law, changes to the trust, I mean. However, what that discussion implied is that there is no mistake in a trust. However, when it comes to fixing a drafting mistake in a trust, the IRS doesn't necessarily have to accept that change for tax law purposes. There is a U.S. Supreme Court decision that controls on this, Commissioner versus Estate of Bosch, where the U.S. Supreme Court held that the only conclusive authority for the IRS, or any federal agency for that matter, when it comes to property rights, is a decision by the highest court in the state. But state courts have to follow state law, and what happens if there's actual state statutes that determine property laws or authorize reformation? In that case, it might be necessary that you don't necessarily have to go to a state Supreme Court decision. The statute itself should be enough for the IRS to accept. And we have a lot of state statutes, especially under the Uniform Trust Code, authorizing reformation of a trust and or a will to fix a scrivener's error now. And what should happen here is that maybe with that state statute, the IRS should be more willing to accept a lower court reformation and not necessarily require an appeal to the highest court in the state because that's costly. And the weight of authority allows the IRS to look at lower court decisions in state law after giving proper regard to lower court decisions and the law that would be applied by the highest court in the state. So with state statutes under the UTC, that's made it a little bit easier for the IRS to look more favorably at lower court opinions approving a reformation if those reformations are authorized by statute. Now, there's still not absolute deference here. It's important to note that the letter rulings are implying that the reformation should be in the nature of correcting an error and not necessarily modifying a trust simply for the sake of saving tax. Now that seems like a catch-22, and that's so nuanced that it's hard to really explain the difference here, but it's one of those things to keep in mind that there isn't absolute deference by the IRS, even though the UTC, the Uniform Trust Code, does allow for reformation. But the big question here, too, is that under the Uniform Trust Code, do you even have to go to court at all? Do you need a lower court decision? Because that can have its own risk and peril. And what the Uniform Trust Code allows is a non-judicial settlement agreement, which may allow for the reformation of a trust if the change is one that the court could have approved. So the parties could privately agree that the weight of the evidence does show that there was a mistake that violates the settlor's intent. But the problem with a non-judicial settlement agreement as opposed to a court hearing is that all trust beneficiaries under the sun have to sign off on the change, including beneficiaries who don't even exist yet, who haven't been born, or who maybe cannot sign due to incapacity by age or physical or mental status. And all of those beneficiaries who cannot sign must also be virtually represented. But the effect here is that the consent to any change to the trust by signature could be treated as a gift by a trust beneficiary to the other trust beneficiaries, which would necessitate a gift tax filing. Now, that seems like a bad outcome on its face, and there's a lot of practitioners out there who are afraid of this, but I just want to leave you with this final concluding thought that sometimes fears are overblown. Depending on the valuation and the type of trust and the remoteness of the beneficiary's interest, it may not be a big deal just to accept that there could be a gift tax liability here that uses up a huge 11.58 million exemption and just file a gift tax return and let the 3-year statute of limitations run if the value of the beneficial interest being quote-unquote gifted by the Reformation is small enough. Thank you for listening to this episode of the 10th of an Hour. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you again for listening, and I look forward to seeing you in the next episode.